In preparation for today's talk, I thought about bringing you some statistics, even though it's not baseball season, about government. And I thought, wouldn't it be nice to know about the growth in government employment, federal government employment, over the years since about 1962. And it's been sort of puzzling to me when we think about government. A lot of people here think that there's a government regulator present with pesky ubiquity whenever you look around, as we say in Spain, when somebody is bothered by someone unwanted at all times, hasta en la sopa, he's even in your soup. But the fact of the matter is that federal civil employment has remained amazingly static since 1962. There were 2.5 million employees in 1962. There are 2.6 or 2.7 million employees now. Compare that with the uniformed military, which went from 2.8 million to 1.45 million, a drop of about 50%. The only rise, significant rise percentage-wise in federal employment appears to be in the legislative and judicial branch personnel, which has gone from 30,000 to 64,000. Maybe some of the participants will be able to explain that apparent statistical incompatibility with our own experience on the basis of the government contracting out. For instance, in our courthouse, we've contracted out janitorial services and court security services, who I'm sure they don't appear as federal employees. The next thing I thought was illustrative of the growth of government was the amount of pages that appear in the Federal Register. In 1936, when the Federal Register started, there were 2,600 pages. There are now 82,600 pages. And an amazing little factoid, which I found, was that, that not included in this tally, are some 15 pages a day devoted to the title page, table of contents, and reader's aids, which are numbered in Roman numerals. So the Federal Register grows apace. Lastly, I thought it'd be kind of interesting to reflect on that other group which we think has grown tremendously in Washington, which are lobbyists. And it's true, the lobbyists have risen by about 20% since 1995. There were 10,000 then, and there are 12,000 now. But the amount of money which has been is spent on lobbyists has gone up 150%, from 1.4 billion to over 3.5 billion. And there's been a drop-off in lobbyists in number since the financial crisis started in 2007. So there is a group which has reduced employability but greater compensation. So with that, let me get on to the introduction of our distinguished panelists. We have first Dean Ronald Cass. Dean Cass will describe the issues that arise when regulation comes from the executive agencies rather than from the legislatures. He's Dean Emeritus of Boston University School of Law, where he served as Dean from 1990 to 2004. He's also president of Cass and Associates, a chairman of the Center of Rule of Law. He served as commissioner and vice chairman of the United States International Trade Commission under Presidents Reagan and G.W. Bush. He was a government member and public member of the Administrative Conference of the United States from 1988 to 1995, and currently serves as a member of the Council of the Administrative Conference appointed by President Barack Obama, and a member of the panel of conciliators of the International Center for Settlement of Investment Disputes. appointed again by President Bush. Dean Cass has taught administrative law as a faculty member at the University of Virginia and at Boston University, where he was the Melville Madison Bigelow Professor of Law and is co-author of a major case book on administrative law, now in its 6th edition. He is chairman of the Federalist Society's Administrative Law and Regulation Practice Group, as well as immediate past chairman of the Society's International Law and National Security Law Practice Group, and also served as chairman of the American Bar Association section on administrative law and regulatory practice. I'll introduce the other speakers before they speak rather than have you try to remember all 3 of them. Professor Cass.
Thank you very much, Judge, for the kind introduction. What you didn't say is that at Cass & Associates, I actually work for my wife. She's the Cass and I'm the associate, so. If I do well, I won't get fired. I have to start with a story because every talk begins with a true story. This is the story of the rabbi and the priest and the minister. And I see Hadley-Ark is already saying, I know that story. And they were talking about different things, and the rabbi said to the other two, if you could listen in to your own funeral, what are the words you'd like to hear? And the priest immediately said, I'd like to hear the words that he was a man of God and a good shepherd to his flock. And the minister said, I'd like to hear the same thing, but I'd also like to hear that he was a good family man. And they turned to the rabbi and said, what would you like to hear? The rabbi said, I'd like to hear, look, he's still moving. Well, we have different things we'd like to hear when we look at regulation. And different people have various takes on that. But right now, I want to start with a couple of different models of regulation that we've had over the years. If you go back to the good old days, and the good old days are whatever happened before you were in law school, the old model was that Congress legislated. And it made relatively clear missions for being carried out. It gave people things to do, like the post office, deliver the mail. And it set fairly clear bounds around the directions. And then the agency, the executive department, actually carried out what Congress told them to do under the direction of the president. That's the old model. Then we came to a point where we realized that government was big and complicated, and the Congress didn't want to take the time to write everything out with great care. They thought that there were some things that really ought to be left to others to do. We came to believe in the expertise of administrators. So the next wave was that Congress would legislate, and it would pass something that gave a fairly broad mission to an agency. It would define the contours of what it did, but it would leave it to the agency to fill in a lot of details. And in this model, there was a lot of discretion with agencies, and what they did was then subject to ex post correction by the courts and to some degree by the executive branch, which didn't so much tell people what to do, but the executive, the president, and people working for the president would kind of look at what agencies did and try to influence things as they were going along, and then try to correct some things ex post, but before they became legally binding. The new model that we are evolving over the last 20, 30 years episodically is a model in which Congress doesn't legislate because it cannot arrive at a consensus on what to do. It will to legislate, it will have legislation introduced, it will debate the legislation, and for a variety of reasons the legislation will not pass. After the legislation doesn't pass, the agency that really was behind seeking authority to get a set of missions from Congress will discover that it actually had the authority all along. And it will then regulate in the absence of any clear legislative authority to it to do anything in the area. And when it does that, it will become a substitute legislature. It will write all the rules itself from scratch. And then the President and Congress will scramble to find ways to influence what it is that the agencies are doing and to corral the agency after the fact. And you see over the last 20 years quite clearly a variety of efforts that have been made to try to rein in the agencies a bit. What I really want to talk about today is what's going on, where we stand in this, how we got where we are, and what we might see in the future, whether we'll see a continuation of this or whether we will see something radically different in the time ahead. As Judge Bay pointed out, we have a relatively static number of civilian employees of the federal government. What he didn't say is with advancing technology, they can do a lot more harm. Now, a lot of people have looked recently at things that have happened. I'm going to get to some of the more recent things. But I want to sort of reach backward to some of the ways that the courts helped us get into the mess we're in, and also show why sometimes letting the genie out of the bottle is kind of hard to recapture it. In the 1950s, the Federal Communications Commission in the 50s and early 1960s was observing the rise of something called community antenna television, which later became known as cable television. And for those of you in the room who have neither hearing nor sight and are as old as I am, you can remember when TV consisted of 2 to 3 channels. They were on some of the time. They had, funny shows like Sid Caesar. And they existed in your little area. There were network shows, but the reach of any television signal was very limited, and once you got past your area, you got this fuzzy stuff on the air, you got the snow on the TV, and you couldn't get things very well if you were outside one of the major markets. So cable television came along, and it said, we can fix this. We can carry the signals other places. And of course, the television stations said, that's wonderful, let's regulate it. Let's stop it from bringing signals in to compete with us. And the FCC, doing what regulatory agencies do, said, of course, we should regulate it, because after all, it's going to compete with current TV. So they went to Congress repeatedly and asked for congressional authority to regulate cable television, and Congress denied that over and over and over. And so toward the late 60s, the FCC said, we had that authority all along, so we're going to adopt regulations. And the first regulations they adopted prevented cable television from taking signals from one market into another. And the case went up to the Supreme Court in a case called United States against Southwestern Cable. And the argument that was made to the court is that this is necessary. It's like the necessary and proper clause of the Constitution. It's necessary to give this authority to the FCC because the airwaves are limited. You can only have so many television stations. And because you can only have so many, the FCC has to intervene and allocate them. And once it's allocated them, if you allow there to be lots more stations taken different places, that'll mess up the allocation. It's sort of like saying we have very limited oil, so we need to ration it. And now we found a huge pool of oil. It's the size of Alaska. Well, we need to prevent that from getting into the market because it'll screw up our rationing, obviously. The Supreme Court looked at this and did what courts often do. It said, well, yeah, that makes sense. The same way that minimum prices for milk make sense as a way of keeping it cheap. Yeah, we can do, yeah, we see that. So they came up with a doctrine of ancillary jurisdiction, and they allowed this to go forward. So the FCC did what regulatory agencies often do. It expanded its regulations, came back with a much more comprehensive set of regulations that really squashed competition and put a lot of responsibilities on cable stations that were expensive, but what would help prevent competition with over-the-air broadcasting. And that went up to the Supreme Court in the 70s, and the Supreme Court in the first Midwest video case said, yeah, that's okay too, but you guys are getting pretty far afield from what your mission is. So about 7 years later, in the late 70s, when the next wave of cable regulation came up, when the Supreme Court got a hold of that, it said enough is enough. You can't, saying that you have some authority to regulate doesn't mean it's infinite. You have to have something that is directly related to your mission and is reasonably necessary to do something you've been told to do. And you might have thought that that would have chastised the FCC, but years later, when they thought they wanted to regulate the internet, they went to Congress and said, we need authority to regulate the internet because this thing is really big and our kids don't understand TV anymore, but they understand the internet. If we want to be cool regulators, we need the authority to regulate that. So the Congress looked at this and said no. And the FCC said, I don't think we can really regulate without that. We need authority. And they went back to Congress, and Congress said no. And the FCC did, a couple of years ago, what it did back in the 1960s. It says, now that we look at this, we've had that authority all along. Because Congress, when it passed the Communications Act of 1934, really was thinking about internet regulation. And well, Al Gore was thinking about internet regulation. Our daughter, we have a 14-year-old daughter, and she asked the other day what an allegory was. I said he was a very bad vice president who went on to make very bad movies. The FCC decided that it had the authority to regulate the internet, and not only could it regulate the internet, it could also tell those people who bring you the internet by providing the service that carries the signals. It could tell them what they could price different things at and could forbid them from having different tiers. Those of you who have the occasional outage in your service the way we do may want to have your internet provider do things that will actually make the service work better for most people. And is, of course, in the interest of the people who are building the lines, investing the money, and creating the property to do that. Like many other places, property rights turn out to be good things here too, which is why you need government to prevent them from working. And so the FCC adopted a set of rules that did this and applied them first to Comcast. The case went up to the DC Circuit, and the DC Circuit, in a fit of real reasonableness, struck down the rules. It said, look, you don't have authority to do this. You really need to keep what you're doing directly related to your mission, and you have to show that it's necessary to carry out what you've been told to do. And having said that in no uncertain terms, the FCC took this very humbly and went back and reenacted its rules, which will go back up to the DC Circuit, and we'll see what they say this time around. My version of the opinion would be very short and simple. What part of no did you not understand? But that is something that we'll wait and see what the DC Circuit does. Well, we have another agency that does a lot of the same things, EPA. EPA is an agency that has repeatedly gone and sought legislation. It was backing strongly the cap and trade move. That turned out not to go very far. Congress decided not to pass it. And after that, EPA decided it actually had that authority all along. It could regulate a variety of things, including things like carbon dioxide as a pollutant. And a lot of people said if you regulate carbon dioxide as a pollutant, you're in the soup, because it is ubiquitous, it's everywhere, it's clearly not what was intended to be covered by the Clean Air Act. And the EPA looked at its laws, which if it declared this to be a pollutant, gave it a real problem, and said, we're going to do this in a very sensible way. We're going to rewrite the law. We're going to say it's a pollutant, and we have the authority to regulate it, but we're going to adopt a rule saying we're exempting almost everything that would be subject to the rule, because it would be absurd to have a rule that did what we say the law tells us to do. And they're doing this again in a new rule they've passed called the Utility MACT rule, which is going to have about $100 billion cost to utilities to have them redesign the way they produce energy to reduce the discharge of a variety of pollutants. One of the questions we have is, as we have authorities finding themselves enabled by things like this, is this really peculiar to the FCC and EPA? Do we need an Occupy EPA movement in Washington? Or is this going to be more generally what regulators do in a world in which there are tight budgets, there is a political impasse, and there's not a lot of likelihood of finding real legislative enactments coming up? I will end with just one thought here, and that is that a lot of people on both sides of the aisle look at what's happening in Washington, and they have just horror, although for different reasons. And it reminded me of the question. I'm a longtime Washingtonian and Washington football fan, and I was asked by somebody, why are the Redskins like Billy Graham? To which the answer was, both have the capacity to make a football stadium full of people jump up and yell, "Jesus Christ!"
Thank you very much, Ron. Our next speaker is Christopher DeMuth, who will compliment Dean Cass somewhat in discussing the unilateral executive government, the underlying causes of which are not necessarily partisan. He will develop three proposals. One, the issue of moratoriums. Two, discussion of the RAINS Act. And three, the cost-benefit standards as applicable in the APA, the Administrative Procedures Act. Christopher DeMuth is a D.C. Searle Senior Fellow at the American Enterprise Institute. He was president of AEI from 1986 through 2008. Mr. DeMuth was previously the editor and publisher of Regulation Magazine, the managing director of Lexicon, Inc., an economics consulting firm, an administrator for information and regulatory affairs in the U.S. Office of Management and Budget, and executive director of the Presidential Task Force on Regulatory Relief in the early Reagan administration. He's a lecturer and director of regulatory studies at Harvard's Kennedy School of Government. He's a lawyer in private practice and a staff assistant to the president and director of the White House Task Force on Environmental Policy in the Nixon administration. His articles on government relations and other subjects have appeared in the Public Interest, the Harvard Law Review, the Yale Journal of Regulation, the Wall Street Journal, Commentary, and other publications. Please welcome Christopher DeMuth.
Thank you very much, Judge Bay. But the most important item on my resume is that I was at Chicago Law School as a classmate with Dean Cass. Proposals to reform the regulatory process are always incited by some series of regulatory initiatives, and the incitements for the current proposals are all around us today. Hundreds of rulemaking proceedings under the Dodd-Frank and Obamacare statutes, the EPA's extremely aggressive rulemaking agenda involving greenhouse gases and many other matters under the Clean Air Act, the FCC's ambitions to regulate the internet, numerous proposals for energy efficiency regulation, from tightened CAFE standards to the impending abolition of the incandescent light bulb, and standing above all of those, a truly amazing display of unilateral executive branch government in recent years, involving such things as the emergence of the new Consumer Financial Regulatory Bureau, which is entirely cut free of legislative appropriations. It lives off of automatic allocations from the profits of the Federal Reserve banks, to the BP oil spill program, whose authorization is a White House press release, to numerous waivers provided informally under Obamacare and other statutes. This gives it all a very partisan cast. We had an election a year ago, and that produced, courtesy of the Tea Party movement, a change in the political leadership of the Congress. Before the new Congress even arrived in town last December, that election produced a significant change in the trajectory of tax policy. It has since produced important changes in the trajectory of spending and borrowing, debt policy, but essentially nothing in the way of regulatory policy, where the new members of Congress have discovered to their dismay that very little happens on Capitol Hill other than holding hearings and writing letters. The real lawmaking takes place downtown. But the partisan cast of the current debates are deceptive. Regulatory growth over the past 40 years has been remarkably continuous from administration to administration and essentially bipartisan. If anything, the greatest spurts in regulatory growth came under the administrations of President Richard Nixon and George W. Bush. And in many respects, it was the Bush administration that set the table for today's high-volume regulatory activity. All of the new energy efficiency standards, the incandescent light bulb, the CAFE standards, were enacted under the Energy Security and I forget what it was called, the Energy Independence and Security Act of 2007, which was a Bush administration initiative supported by many Republican leaders in the House and Senate. The Bush administration took the initial, albeit reluctant, steps toward regulating greenhouse gases under the Clean Air Act. The Sarbanes-Oxley legislation in 2002 took a big step toward unilateral executive branch taxation with the Public Company Accounting Oversight Board. It's a 501c3 not-for-profit chartered in the District of Columbia. It's just like AEI and the Federalist Society, except it gets to write and charge its own taxes. These are not user fees like at the FDA. They're not like admission fees at Yellowstone Park. It's a true tax that is calculated annually to raise the budget that this agency feels that it needs. Obamacare is unique in many respects, but let's remember the Medicare Part B pharmaceutical drug benefit, the first major national entitlement program enacted without a penny of revenues to pay for it. It is all being financed by selling bonds, and was in establishing this precedent of a big middle class freebie, moved us significantly in the direction of pharmaceutical price controls. Most of all, Dodd-Frank is a natural outgrowth of the amazing executive branch response to the 2008 financial crisis, where the alliance of the Treasury Department and the Federal Reserve made de facto appropriations on their own of many hundreds of billions of dollars, used regulatory authorities in obscure ways to compel the mergers of many financial firms. At the end of the year, Congress finally got into the act with its own appropriation, the $700 billion TARP program. 2 weeks later, the Treasury Department announced that the money was to be used not to purchase troubled assets, but for very different uses that many in Congress felt were antithetical to the law that they just passed. The Congress rose in bipartisan outrage. Within a month, it was cooperating with what the executive branch had done through supporting legislation. There are certainly some partisan differences between the two parties on regulatory policy, but the essential problems are not. The essential problems are institutional. The invention of the regulatory agency is the most important innovation in government since the Constitution. The Constitution tried to make lawmaking difficult. The regulatory agency makes it efficient. The hierarchy, such as the EPA, can produce law vastly faster than our bicameral Congress with its complex layers of committees. The single-purpose agency is completely unconflicted. The representative legislature must work compromises among competing interests and values. That's no problem at the single-purpose agency devoted to telecommunications or environmental policy or financial disclosure. Most of all, the resources that the agency is working with are almost entirely unconstrained by the mechanisms of public finance, budgeting, authorization, appropriation. As a result, it's not only a single-purpose agency, but it has far less incentives than the single-purpose but budget-constrained spending agency to take account of alternative public and private uses of the resources that it has the power to command. The legislature has accommodated itself in many ways to the emergence of executive branch lawmaking. As has been emphasized by Ron, the legislature gets to take credit for making a firm decision on behalf of clean air, safe products, and leave the real lawmaking, the real hard decisions to the executive branch. Here is our financially independent Consumer Financial Protection Bureau's mandate from our lawmakers. Ensure that all consumers have access to markets for consumer financial products and services, and that markets for consumer financial products and services are fair, transparent, and competitive. Full stop. There are four major proposals afloat for responding to the growth of regulation. The first is the idea of a moratorium on legislation. This has been proposed by several academics such as Alan Meltzer, John Taylor, George Shils. Several legislators have proposed bills that would put a moratorium on legislation until the unemployment rate falls to 7.7%. I regard this proposal as completely unworkable. To see why, just realize that this brief two-page law would in a stroke work a partial repeal of both the Dodd-Frank and Obamacare statutes, which are entirely engines of rulemaking. There would undoubtedly be a necessity for lots and lots of exceptions for one or another real or imagined emergency. It would not change regulation at all. It would not address the underlying problems I've mentioned. It would simply postpone them for a time. The second is the idea of a regulatory budget, where we would try to mimic what we do with spending programs by estimating the total costs of all federal regulation and giving each agency a budget of how much cost its policies could impose during a given year. It has some nice theoretical attractions. I think that it is also unworkable and would run aground on the many difficulties of estimating regulatory costs. Doing that for the whole government would be a Herculean task. As a result, Senator Warner has a modified version, a pay-go proposal, which simply says that an agency has to repeal one rule on its books for every new one that it adds. It's nice, but it is highly marginal given the overall problem. Third, and the most ambitious, is the so-called REINS Act, Regulations from the Executive in Need of Scrutiny. This would take the Congressional Review Act of 1996, which has expedited procedures for legislation to disapprove agency rules, and instead have those procedures for needed legislation to approve rules. Regulatory agencies would essentially be specialized legislative proposal organizations. Major rules could not take effect until approved by both houses of Congress and signed by the President. I myself would be delighted to see Congress spending more of its time overseeing the laws that it has already passed rather than passing new laws. If you ask yourself, should Congress be in the loop on a 100 billion or more decision, it is hard to say no, but it is well to acknowledge the radical nature of the REINS Act. It throws itself athwart 100 years of development in the nature of government in all of the advanced democracies, America, Europe, Japan as well. The migration of lawmaking authority to administrative agencies certainly has very deep political, economic, and institutional causes that are not going to be easily reversed. REINS essentially would set the federal government on a path to a size and scope consistent with the decision-making capabilities of our Congress. That is a truly radical change. Whether Congress is willing to do that, to try to do that in one stroke, whether it is willing to add to its annual legislative agenda 75 to 100 new, highly procedurally privileged pieces of legislation, it's going to make for an interesting debate. The fourth, and I want to say a few words about this in conclusion, is the proposal to amend the Administrative Procedure Act essentially to embrace the cost-benefit standard that has been in executive orders from Ronald Reagan in 1981 down through the present under a new order issued by President Obama at the beginning of 2011. It would essentially codify that standard and those practices, but apply them to the so-called independent agencies, and most of all, make the cost-benefit standard subject to judicial review. My personal view is that this proposal combines feasibility and effectiveness to a greater degree than any of the others. First, it would be the closest feasible regulatory analog to a budget constraint. Individual rules would be constrained not by an overall spending level allocated to agencies, but rather by estimates of the benefits that individual rules would produce. Second, it is an appealing rule of statutory construction in cases where legislative standards in the organic statutes are extremely general. What is the faithful regulatory official to do with a mandate such as the one I quoted for the Financial Protection Bureau? You can't find out by asking individual legislators. We took a vote and they couldn't as a whole say anything more than the general sentence. Some legislators want more zealous enforcement, some less. Some legislators taking the entire regulatory establishment want more, some want less. But if you ask, what would the consensus of all legislators be for how every regulatory statute should be enforced, it's hard to do better than to propose that each individual statute with a general mandate should be enforced in the most cost-effective manner possible. It would be an important force. It has proven an important force for transparency. Regulatory proceedings are enormously complex. The issues in play involve endless details. Cost-benefit analysis is simply a procedure for summarizing all of the considerations as best as possible. The cost-benefit standard in the executive branch did not come because economists somehow took control of the West Wing of the White House. It came because busy, harried White House staffers had heard that there was something afoot at the Transportation Department or the Federal Communications Commission and needed an efficient, quick briefing procedure. Why is this a good idea? How much is it going to cost? That's where we got the cost-benefit standard. It builds upon 30 years of bipartisan policy within the executive branch. The maximum net benefits rule has been embraced equally by Ronald Reagan and Barack Obama. Having had 30 years of practice, it is sufficiently established for legislative codification. Finally, it would improve very substantially on the rather indifferent results of the internal executive branch procedures. They are internal. The agencies and OMB fight like cats over policy decisions, but then they have to present a united front to the outside world. Many compromises are made. If you look at the Obama administration's claims of hundreds and hundreds and hundreds of billions of dollars of net benefits from its regulatory decisions so far, benefits so great that we really don't need another stimulus program. If you look at their numbers, although they're offered, in a very circumspect way, they are hiring people, creating jobs, creating benefits for the public beyond the stimulus bills. Well over half come from just two things. A few studies that show fantastic benefits from reducing airborne particulates from very low levels to even lower levels, and two, the purely private benefits, not public benefits, of requiring people to spend more today for energy-consuming appliances in exchange for estimated savings in energy expenses in the future. Purely private benefits. If we accept that, then the government might as well have us all go out and buy a pair of galoshes. If the cost-benefit standard had some outside enforcement with the usual deference that courts show, we would have real discipline in the internal deliberations. We would have, over time, the development of a common law of what the cost-benefit standard means in the context of a variety of different regulatory initiatives. We would have developed an outside body of criticism as economists and reviewers reviewed the decisions. An initial example of the kind of thing we would see would be the D.C. Circuit's decision in Business Roundtable versus SEC this past summer. Over time, if this was a judicially enforceable standard, we could hope to see the development of, in regulatory practice, of a degree of professionalism and of economic literacy that we have come to see in antitrust enforcement in the past 30 years. Thank you.
Next, we have the pleasure of Professor Cary Coglianese from the University of Pennsylvania. Professor Coglianese is perhaps more friendly towards regulation than the first two speakers, and he'll describe those areas in which he agrees with them or disagrees with the first two, and we'll discuss what we frequently hear as an effect of regulatory administration, which is paralysis by analysis. And he will discuss other proper procedures. Professor Coglianese is the Edward Shils Professor of Law and Professor of Political Science at the University of Pennsylvania, where he serves as the director of the Penn Program on Regulation. He specializes in the study of regulation and regulatory processes, with an emphasis on the empirical evaluation of alternative regulatory strategies and the role of public participation, negotiation, transparency, and business-government relations in policy making. He has published widely on a variety of regulatory issues, including the uses of information technology in the regulatory process. His most recent books include Import Safety, Regulatory Governance in the Global Economy, and Regulation and Regulatory Processes. Prior to joining Penn Law, Coglianese spent a dozen years on the faculty at Harvard University's John F. Kennedy School of Government, and he also has taught at Stanford and Vanderbilt Law Schools. He founded the Law and Society Association's International Collaborative Research Network on Regulatory Governance and served as a founding editor of the journal Regulation and Governance. At Penn Law, he founded and serves as faculty advisor to regblog.org, a daily online source of news, analysis, and opinion on regulatory issues. As co-chair of the American Bar Association's Administrative Law Committee on e-rulemaking, he has led a National Science Foundation initiative on e-rulemaking, served on the ABA's Task Force on Improving Regulations.gov, and chaired a task force on transparency and public participation in the regulatory process that offered a blueprint to the Obama administration on open government. He currently is working with the Administrative Conference of the United States to develop recommendations on the use of information technology in agency rulemaking. Let's welcome Professor Coglianese.
Thank you very much, Your Honor. I appreciate the kind introduction. I testified in front of the House Judiciary Committee a few years ago, called by the Republican staff and the Republican members. At that time, the Democrats had control of the House, and being the only witness there for the Republicans, I don't know that the majority on the committee would have characterized me as friendly to regulation in that particular setting, but here I am today in front of you, and I am perhaps, as the judge says, characterized as the more friendly to regulation. I'm a friend to regulation in the sense that a scientist who studies bugs is friends to bugs. I'm here and dedicate my research agenda to studying regulation as a social scientist as well as a legal scholar. I want to pick up on the title of our panel here, Reining in Regulators, and make some comments about the role that law and procedure can play as a behavioral tool for shaping the behavior of regulators and the outcomes of regulatory policy. Reining in suggests, to me at least, more than just stopping, because that's one thing that reins can do for a horse, but also steering. And as anybody who's done any horseback riding knows, you want the horse to go in a certain direction and not in other directions. And part of what procedures and laws that govern the regulatory process try to do is, in some cases, stop the horse, but in other cases, move it in one direction or the other. I find it's interesting that when looking at the substance of regulation, those that are maybe right of center on the political spectrum focus a lot on the costs and burdens of regulation as they impact businesses. And then those that are left of center focus on the benefits of regulation, the health and safety payoffs and so forth that come from different regulations. When we look at the rhetoric and the positions when it comes to the procedures and rules that guide, the reins, if you will, that are used to shape the behavior of regulatory agencies, things flip, not surprisingly. The folks on the left focus a lot on the costs of those rules and procedures. So the type of legislation that Chris was talking about, those on the left rail against it as imposing too many costs on the process. And there's too much regulation of the regulators, and of course you get the different view on the right. What I'd like to do is take one particular example, pick up on this legislation called the Regulatory Accountability Act that Chris mentioned last as the one that, as he argued, was the most feasible and probably the most effective regulation of the regulatory process that would apply the cost-benefit test in statute to agencies, the same test that exists right now in executive order. It would apply to independent agencies. It would put some judicial review of that cost-benefit process. One major argument that has come up against this legislation, which has now cleared the House Judiciary Committee, although it's been it's unclear how far it will go in the Senate, but maybe it is the most feasible approach. It is a piece of legislation that has bipartisan support, but the folks on the left are railing against it for imposing too many costs and too many burdens, not on businesses, but on the regulators, okay? So if you look at the statement of an organization called OMB Watch, they say, quote, that this act would seriously undermine public protections by slowing down the regulatory process, sparking endless litigation. In testimony recently before the House Judiciary Committee, Sid Shapiro of Wake Forest University Law School and a member of the Center for Progressive Reform, a left-of-center law professor organization, he testified that the regulatory system is already too slow. It currently takes, he says, I'm quoting, 4 to 8 years for an agency to promulgate and enforce most significant rules, and the proposed procedures in this legislation would likely add another 2 to 3 years to the process. Then, of course, I don't know, using math that I'm not familiar with, he says that the legislation, under the legislation, quote, the longest rulemakings could take more than 12 years. Now, I don't know, 4 to 8 years plus either 2 to 3 years. I get at most 11 years, but no, it's actually more than 12 years. Put aside the math about that, is this claim true? If it is, maybe that's a good thing. Okay? Maybe it's not. But I want to put aside that for a moment and just ask empirically, is this likely to be true that adding these kind of procedural requirements that are in place right now under executive order and have been, as Chris said, since the Reagan administration, is this likely to slow down the regulatory process? I want to suggest two things. First, these claims about quote-unquote paralysis by analysis are not new claims at all, not at all. And second, they're not claims that are consistent with the available research evidence that we have. As mentioned, since the Reagan administration, a review process of economic analysis has been in place. Right in the Harvard Law Review, right during the Reagan administration, there was an article published that said that OMB controls impose costly delays that are paid for through the decreased health and safety of the American public. That was in the Reagan years. When President Clinton amended the executive order, it gave rise to, again, a renewed set of criticisms that this review process would slow down the regulatory process. When President Bush, second President Bush, made some additional changes to the Clinton executive order, it unleashed a fury of rhetoric that, quote, this executive order deals a body blow to the ability of our agencies to do their jobs, quote unquote. That it would, quote, keep the agencies in an endless loop of analysis and will lead to endless regulatory delays. And I could go on and on about the claims of gridlock and delay, the sand in the gears of government that the White House Executive Office review process would impose upon the regulatory process. These kind of claims have not been limited to just the White House review process. The National Environmental Policy Act, which imposes analysis requirements for environmental impacts, has been criticized as postponing federal action. The Freedom of Information Act has been criticized as imposing high costs on federal agencies. The whole notion that the judiciary should have the ability to review the acts of regulatory agencies has been widely criticized and denounced as leading to the ossification of the regulatory process. The claims about paralysis by analysis are so prevalent and have been over the past several decades that it has become a bit of a cliche. What's probably less understood or recognized is that these kind of claims date back to the very founding, if you will, of the administrative state in the United States. Since the creation of the Administrative Procedure Act in the 1940s. A few years ago, I went back and looked through the literature in the 40s, and you could find in the Harvard Law Review in 1938 an administrative law scholar claiming that the changes being proposed at that time to impose some structure, some central legislative body of procedures, some reins, if you will, would lead to, quote, a partial paralysis by reason of excessive formality and litigation. The very same claims that we're hearing today being leveled in opposition to the imposition of the kind of reforms that Chris spoke about. And actually that wasn't an isolated claim. They can find a number of similar claims throughout the literature at that time that there would be nothing short of a sabotage of the administrative process. So these are, as I said, my first point is these are not new claims. The claims that we impose some procedures on government and it's going to grind it to a halt have been with us for a long time. What about the second point? Are they actually empirically true? Well, you heard the judge talk about the vast growth of government over a period of time that has had these procedures in place. The Code of Federal Regulations, I think, is the better test of the volume of regulations we have in the U.S. rather than the Federal Register, because the Federal Register has all sorts of other notices and documents in it. It also has all the proposed rules, not all of which are adopted, and it also has all the preambles. If you just look at the operative words in the Code of Federal Regulations, the binding regulations, the CFR today has about 33% more pages in it than it did in 1980 before the Reagan administration adoption of White House review. You've seen an accretion of, if we look at the impact of regulations that have enormous economic effects since that time. A few years ago, the National Highway Traffic Safety Administration conducted a study in which it tried to compute the amount of costs that go into making a car, the average car, that are due to auto safety regulations. During the period of the late 60s through the late 70s, NHTSA estimated that $255 of every car were attributable to auto safety regulations. By the period 1991 to 2001, that had more than doubled to $760 per car. Analyses of environmental regulations have shown, even in the period before and after the imposition of White House review, that the costs of complying with environmental regulations have more than quadrupled. So even though it may seem intuitive that imposing additional procedural requirements on agencies might slow things down, and again, maybe that's a good thing or maybe that's a bad thing, but the empirical reality should lead us to question whether we really can rein in the regulatory process through additional procedures. There have been a few careful social science research projects that have tried to assess to what degree the White House review of economic analysis right now slows down the regulatory process. A study a few years ago by political scientists Cornelius Kerwin and Scott Furlong found that there was very little by way of any statistically significant effects on the duration of rules that went through OMB review versus those that didn't. Another social scientist, Stuart Shapiro, when he was a doctoral student of mine, designed a study in which he compared the pace of rulemaking in states. And he conducted a matched case study design where he took states that had a lot of procedural requirements, a lot of reins, if you will, on the regulatory state, and states that didn't. but were comparable in other respects, regionally and in terms of their politics and political structure. He found very little difference in terms of the pace of rulemaking in states that had a lot of these procedural requirements and those that didn't. Another more recent study by political scientist Steve Bala and some colleagues found that when there were a lot of business groups that were in contact with the White House over regulations that were going through the OMB review process, they were actually shorter in their duration, not longer. So we have no broad-based empirical study that has yet to find that adopting procedural requirements for economic analysis have slowed down the regulatory state. It may be the case that for some individual rules, they have taken longer, but across the board that doesn't seem to be the case. It's also possible, by the way, that there would be at some point a tipping point, if you will, an accretion of enough procedural burdens on an agency that it would have a discernible effect, but notwithstanding the very consistent claims since the 1940s that there would be this paralysis, government regulation churns on and on and on. It is like the Energizer bunny that keeps going. So what are we to make of it? One thing might be to doubt really the effect that procedures and additional procedures can have. I'm a believer in analysis. That's what I teach a class on policy analysis. So I think it's a good thing to look before you leap. But mandating that doesn't necessarily lead to a paralysis by analysis. But it also might not lead to truly reining in the burdens, the size, and the scope of federal regulation. If I return to the metaphor of a reins and a horse rider, it may be that we can rely less upon the mechanical procedural devices, the reins, if you will, and what may really make more a difference is who's actually riding the horse.
Now comes a time for questions, and so I'll ask one general question and then turn the questioning over to the members of the panel. I'd like each of you to tell me, from your point of view and from your analysis, what role you think the federal courts can play in making the regulatory process more efficient.
Well, I think there are two things that the federal courts can do to make the regulatory process more efficient. And the first is to apply a set of predictable rules to all cases, regardless of the subject matter of the case. When you look at a case like a Mass against EPA, that is a case where all traditional administrative law doctrines are applied with the word "not" inserted into each doctrine. We will not apply the rules on reviewability, we will not apply rules on deference, we will not apply rules on statutory construction. They take two provisions of the EPA, one of which says that you may do something and one of which says you probably may not do something, and puts them together and says, therefore, you must do something. I mean, it's sort of, if courts are going to play the role of honest brokers in just interpreting the basic doctrines of administrative law, that's a step in the right direction. Second thing, both Chris and Cary talked about economic analysis, cost-benefit analysis, and the role that plays in regulation and under proposed changes to regulation. While cost-benefit analysis is malleable, it is not infinitely malleable. Economics can be used in different ways by different economists, but there's a certain core accepted by pretty much everybody of economic analysis. And I think to the extent that the courts can essentially hold agencies' feet to the fire to make sure they don't go outside the bounds of accepted cost-benefit analysis, that it is sort of playing fair in its use of data and analysis, that would be a help to the process.
Professor?
Well, I think there's certainly a role that the courts clearly play in our political process. Whether they can be the drivers of greater efficiency in regulation, I'm, if not agnostic about, maybe even more strongly skeptical about. The judges typically wouldn't have the time or the resources to do the actual analysis that would go into making a determination of the best policy. So, one can fall back on sort of a pablum that says judges should try to encourage agencies to do that kind of work themselves. I think we know far too little about how judges, as an empirical matter, play a role in doing that. It may be the case that having to defend a benefit cost analysis before a judge will lead agencies to do a better job with their analysis at the outset. But on the other hand, we have a history of judicial review that's really quite deferential to agencies and to agencies' expert judgment. So it may well be possible to continue there are some agencies that perform rather shoddy analysis, and if they can get away with that kind of shoddy analysis by reporting it to the White House, I'm skeptical about whether reporting it to a judge who is going to have a clerk or two looking at it versus the whole set of economic analysts that the Office of Information and Regulatory Affairs has is going to make that much of a difference.
Chris?
There's a certain ambiguity in the idea of efficiency in the question. The most efficient thing would be for the courts to say anything goes and to leave completely unbridled discretion. That was actually the initial idea of the New Dealers. They thought that administrative decisions should be subject to no review at all. The Obama administration has pursued this in a couple of cases in recent statutes. We'll see where that goes. Cary mentioned that the Federal Register has gotten to be an imperfect measure of regulatory growth. One is that the Administrative Procedure Act says that an agency shall give a concise general statement. In effect, the price, if you look at all of the appellate decisions together, the price of Chevron-style deference is that you have to explain yourself at length. There are no concise statements in major rules. They go on for pages and pages and pages, reciting every conceivable consideration. So, in a sense, things have gotten less efficient. The agencies have to explain themselves more. It's a sort of a price of their legitimacy. I think it hasn't been very effective. Agencies will throw in everything but the kitchen sink. And it is my view that a properly tailored cost-benefit analysis could change that. And again, I'd refer you to the Business Roundtable Chamber of Commerce decision on the SEC proxy rules, where you have an extended presentation by the agency, but where its analysis of the benefits of the costs is, and this was an extremely conclusory, tendentious, manipulative. A reviewing court can see that. It doesn't have to do the analysis for itself. It can simply point out the inadequacies of the agency and tell them to go back and start over. I think that over time, the development of judicial doctrine on an economic test for regulation, similar to what has developed in the area of antitrust, will actually make decision-making in the executive branch more efficient in the good sense. You know, the rules will be clearer. The enormous amount of game playing between the agencies and OMB that goes on today will be forestalled once the rules of the game and an outside enforcer are clear. So I think we'll get actually a better kind of efficiency resulting from constrained rather than unconstrained discretion.
Before we take questions from the floor, I'd like to give the panelists a chance to ask questions of each other, and we'll start with Professor Coglianese, because you came last. Do you have any questions of either of these two gentlemen?
Well, I was just going to ask if anybody has any hunches on whether we actually will have any of this regulatory reform legislation adopted in this Congress or not. What's your handicap of the situation?
How about you, Chris?
There's always a safe answer to that question. It'll never pass, because it almost never does. But I mean, there's a certain amount of momentum. The Congress, the Senate passed a cost-benefit standard in, I think, 1982, never went anywhere in the House. I think we might see something like a reversal of that this time, although there's, especially in the financial area, at the Banking Committee in the Senate, there's really genuine bipartisan interest in something like this, and that might grow into a broader piece of legislation.
How about you, Ron?
Well, my sense is that if Herman Cain were speaking German and were asked, will we get serious reform, he would say 999. But, it's always possible. I think it's always an uphill battle, and by the time you get serious reform, it's usually watered down to a point where it doesn't do what you want it to. I do notice we have a lot of people there, so I'm not going to ask any questions of my fellow panelists.
Okay, thanks. We'll go to the members of the public who are standing up and waiting. Please state your name, where you're from, and to the greatest extent possible, make it a question and not a declamation.
Adam Gustafson, Cooper and Kirk. Mr. DeMuth, from your final comments there, it sounds like the real problem might be with judicial deference, and that any cost-benefit analysis will really just be subject to the same deference that you've already taken issue with. It seems like to the extent Chevron is already a box-checking exercise, the cost-benefit analysis becomes just another box. And as has been pointed out, it's already, at least in the executive branch, it's already one of the list. So isn't the real problem with Chevron, and why isn't there a proposal to legislatively override Chevron, if that's what you're taking issue with?
I would not be for that, but my view is that a proper statutory expression of, in effect, a maximum net positive benefits rule would lead to a degree of contention among the parties on the actual issues in the case. That would lead to much more illuminating decisions. And I'll just say it again, look at we have a model here in some statutory language in the securities statutes that it was an admittedly extreme case, but cutting out the outliers are pretty substantial. Now, if you take something such as the scientific bases of the EPA's estimates of benefits from further reductions in particulate matters, that's under any construction, that's going to be very, very difficult. And to have the courts second-guessing the question of a linear dose-response curve for a particular kind of toxin is, I think I just think it's unworkable. You're going to have some considerable deference in cases like that in all events.
Professor McGinnis?
It's John McGinnis, Northwestern. My question is also to Chris DeMuth. I certainly understand the problem of congressional capacity about the accountability statutes. On the other hand, the problem of democratic deficit and accountability and regulation seems to me a huge one that goes beyond cost-benefit analysis. And couldn't that be dealt with, the question of capacity, by changing the structure, by requiring that anything with a cost of over $100 billion have to be approved by Congress, and that could have judicial review, or by taking some particularly out-of-control agency and requiring just that agency to go through Congress. In any event, then we would have some better experiments on what this would do and see whether it would achieve its goals. So it would at least allow us to experiment with greater accountability, which is something I think we need.
I don't disagree with that. I would be perfectly happy to see the Congress experiment. What you've described is pretty close to Reining. It's only major rules, $100 billion a year or more in economic impact that would be subject to this prior statutory approval procedure. I'm all for trying those things. I'm simply pointing out that we're talking about a 100-year phenomenon that we're trying to catch up with here. Actually, my favorite approach would be a more rigorous application of the non-delegation doctrine, which would lead to Congress's actually having to make decisions when it passes something like the Clean Air Act or the Consumer Financial Bureau. If Congress really wants to take back the reins, it can do so. It doesn't need these special procedures. It can rewrite these acts. The Clean Air Act is now 40 years old. It's very badly out of date. It's a really great 1970s approach to air pollution. It's completely irrelevant to air environmental issues today. And I'd like to see Congress take control of that and actually make decisions. And I say that even though sometimes when it makes decisions, like banning the incandescent light bulb, I hate what it does. But I think that we would get a more balanced and effective set of regulatory policies as a result.
On a footnote, the last non-delegation case that I can recall involved a sick chicken in 1935, right? We may have to wait a while.
Right.
Next question.
I'm Cameron Smith. In the interest of full disclosure, I was counsel for Jeff Davis, who's the principal architect of the Reining
Right.
Act. I'm also, incidentally, a resident of Jefferson County in Alabama that just submitted a $4.35 billion bankruptcy filing, largely stemming from federal regulation under the Clean Water Act. The question that I would sort of ask all of you, and at the risk of being unpopular in a room largely full of regulatory attorneys, do you think the economics are such that you could ever really change the regulatory state? Because in working on the Reining Act, one of the common refrain that I heard was, well, we have really good relationships with our regulators. And I was having lunch with an attorney yesterday at a very large firm in D.C., and he said, well, effectively, you've got legions of attorneys that are billing hours that are transaction costs based on a regulatory state. That's complicated. If you simplify that, shrink that, streamline that, those transaction costs diminish, and so you have divergent interest in simplifying the regulatory state. Do you think that it's ever possible, given these economic interests and the size of the regulatory state, to truly enact many of these reforms?
Let's let Professor Dean Cass.
Well, first of all, I don't think that the chief impediment to regulatory reform is the set of lawyers who work on regulatory issues. There are larger political forces that give us the laws we have and the regulations that we have. And one of the problems when we debate regulatory reform and when we debate what's going to happen in the courts, things have developed the way they have for a set of reasons. It doesn't mean that they're immutable. It doesn't mean we can't change them. It doesn't mean we can't make them better. But as Judge Bay said, when you look at things like the non-delegation doctrine, we've had periodic efforts to try to resurrect it. The American trucking case. We have an occasional effort to try to make sure that Congress actually legislates the at least clear directions, if not all the details of the law. It's a difficult thing to do. There are lots of pressures to get things done. There are lots of complicated things. We certainly don't want Congress passing on the approval of every drug. There are things we want to have delegated to agencies. And efforts to give some vigor to these doctrines tend to be very short-lived. I think that the question on deference is one that you can have a rule of deference to agencies but still require them to do serious analysis. There are some ways we can make gains, at least at the margin.
Professor?
Well, I think I guess the larger question is there any room for hope? And I think it depends on, what you see as the problem. There are, I think there are on both sides of the aisle in Congress, people who are disaffected with regulation. I have a book coming out next year called Regulatory Breakdown, The Crisis of Confidence in the U.S. Regulatory System. I think on all sides you have people who either see great calamities happen, like the BP oil spill, and then and say that there's not enough regulation, that Congress and the agencies are too slow to react and too feeble. We don't have enough. Then you have people on the other side who look at the sustained and deep economic crisis the nation is facing and want to find fault with regulation for that too. And it may well be that what we do is we put all of our hope in law, and we are a society that has done that. Tocqueville talked about every controversy ultimately becomes a legal controversy. And regulation now is really the repository for all of our hopes and all of our fears. So it's become an issue that's highly polarized, and whether we can make progress is, I think, partly in the eyes of the beholder.
In another field, I just want to put a footnote again. In another field where cynicism about the symbiotic relationship between lawyers has not proved to be an impediment to reform, whether you're for it or against it, is in tort reform. There was a lot of talk that defense lawyers didn't really want tort reform because a lot of their business would go away. That hasn't been the experience of certain states. So you might think about that as an analogy. Chris, do you have something to add to that? Okay, next question.
Hi, Crystal Lyons from Boston via Los Angeles. I also have a question on Chevron deference. And I know Dean Cass spoke a lot about the problems with the FCC and the EPA going out of their bounds and regulating cable and internet and emissions. And so my question was whether or not we should apply less deference when the agency is interpreting its own jurisdictional authority.
I certainly think that there is reason for the court to be very skeptical of agencies asserting bounds beyond what's clearly given to them by Congress. I don't think we need to have the same degree of deference on jurisdictional authority. And I also think that the courts could do a better job on being clear about where they're giving deference and why they're doing it. When we had just Chevron, we had a clearer set of rules and a combination of Chevron, Meade, Skidmore. Once you get a different level of deference for every conceivable agency and agency rule, you've essentially lost the ability to give people sort of clear guidance on what you're doing.
Next question.
Hi, David Silvers, Georgetown University Law Center. So full disclosure, I work on Dodd-Frank issues outside of school on rulemaking for the Commodity Futures Trading Commission. And what I find seems to run contrary to what I hear a lot of talk about reform. I think we have people there who are good people, who aren't corrupt, who are smart, and who consider costs and benefits. But at the end of the day, there's some issues where we just don't know, where we make rules on what position limits should be for gold, for oil, for things like that. And what I wanted to know is, do any of you think at some point that we have to consider maybe Hayek was right, maybe von Mises was right, and that some of these things that agencies do, the issue isn't procedure, the issue is that sometimes the aggregation of knowledge can't be done, that there really is a knowledge problem to what agencies are doing, and it's not in corruption, but rather that it just can't centrally plan certain things.
The issue is not whether they're good or bad people. The issue is not corruption. The issue is incentives. These are people who work in a field where they have huge discretion over the use of other people's money. That discretion is not bounded by any of the constraints of public finance, which we insist on when the government is taxing and spending money directly. They're working on a single purpose. They're judged by what they do for consumer financial literacy or air pollution reductions. These are good things. They're not bad things. But spending agencies do good things too, and we don't object to the fact that they have to work within a budget constraint. The question on all of these reform proposals is, should the administrative agency operate under constraints?
But at some point, do you think we've really just kind of given away the farm when we give that much deference, and that there's something to be said to the fact that some agencies, some issues can't be planned? You know, we have something like the Consumer Protection Finance Bureau, and it seems to me when you hear someone like Elizabeth Warren speak, she seems to think that if she just has enough moxie, she can determine what the right interest rate is for certain things. Are we really giving too much deference? And at some point, should we say these things shouldn't simply be planned?
Yes. I agree. Yes. Good.
Hi, Dominique Ludvigson. I'm based out of Alexandria, Virginia here. I wonder if there are any mechanisms that exist or should exist closer to the front end to make sure that the cost-benefit analysis is done, you know, whether it's by statute or by executive order, is actually an accurate reflection of what the costs and benefits are. But if you had a judicial review process by the time you got there, it's largely too late, and I'm not sure courts are specifically competent to make those kinds of determinations. So what kind of measures, how are you ensuring that the cost-benefit analysis is not being affected by really the political will to get the regulation done rather than the actual costs and benefits?
Well, let me, if I may, respond in two ways to that. First, you mentioned putting in place cost-benefit analysis up front. And we really don't have any cost-benefit analysis requirements up front in the sense that they're not imposed upon the legislature. And so if you look at the legislation that is giving rise to a lot of regulatory activity, Dodd-Frank, healthcare reform, and so forth, there wasn't a review process in place at that time other than a political process, right? And so some might say, we're really not squarely at the source yet. And if we really want to discipline this, we really need to discipline the legislative process. Second thing I want to say is that no matter what you do about ex ante review before the decision gets made, whether it's in the legislature or in the regulatory process, those are only estimates. They're based only on either theoretical predictions or what we know about what's worked in the past somewhere else. Unfortunately, we don't do very much or not nearly enough serious analysis after the fact to find out what impact regulations are really having or not. We have, since the Reagan administration, put in place this ex ante review for all significant rules. But strikingly, there is very little that demands agencies to go back after the fact and systematically review and empirically assess whether we really did achieve the costs and benefits that we predicted. That, to my mind, would be a great leap forward to do more of that work, because it's going to first feed back into our ex ante reviews and make us much more informed about it, and two, it will help inform these political debates over regulation that right now are driven a lot by ideology in a polarized environment. We can definitely use more information. I think the Obama administration had the right spirit and made a laudable effort with its recent look-back review process. I don't think that they've gone far enough in terms of actually seriously and rigorously evaluating the impact of regulations. It's not enough just to look back and say, the basis of common sense or not, is this working or not? I think we have a great deficiency on program evaluation work that's the type that's done in the educational setting, criminal justice setting, but it's not done as much in regulation.
I'm sorry, I'm taking a look at my watch. It's 12:15, and we're supposed to stop right now so you can get to the lunch and hear the debate between Mr. Clement and Mr. Scott.